Welcome to Litigation Support and Trial Presentation taught online. My name is Shannon Bales, and I'll be your instructor over the next 11 weeks. I've worked in the litigation support field for almost 20 years. I worked for the Orange County District Attorney, the United Nations as a special consultant, and big law firms like Gibson, Latham, and now Munger for the last 15 years. I won the Law Technology News Legal Tech Award for my work at the Cambodian War Crimes Tribunal for Most Innovative Use of Technology at a Trial, and was a finalist for Most Innovative Use of Technology at a Law Firm for my work at the BP oil spill. Litigation support is a field that ranges from collection of data to data analysis and trial presentation. We're seeing a lot of specialization come to the lit support field as each role becomes bigger and more focused. For example, in e-discovery, we now have people that specialize in forensic collection, data analysis, and document review, whereas before it was one role. We're here to learn how to become a trial tech. Most of us in the industry hate that term, and we're looking for a better way to describe our profession. So if you come up with something over the next 11 weeks, please share. Will we start to see the same specialization in trial technology? I think we are already seeing it, and we'll talk about that shortly. What is trial presentation technology? Well, it's the preparation and presentation of exhibits using technology-focused techniques. A good trial tech uses a variety of non-technology techniques to keep the presentation interesting, like boards or a document camera. Nobody wants to sit through 200 PowerPoint slides. Knowing how to call up exhibits on screen is just one part of being a good trial tech. The other is learning about the other pieces that build a solid platform from which to build your presentation from. These are things like trial exhibit databases, organizational systems, and workflows. It is often lost on people that one of the top goals is to make sure that the case continues to move forward and that you are ready to present when asked, no matter what, without excuses. There are not often second chances for an aha moment or to go back and put the exhibits on screen after the fact. As I alluded to before, we are seeing the same thing in trial presentation that we've seen in e-discovery, and that is specialization. The hot seat or trial tech is still the primary role for trial technology, but because of the complexity and size of cases, we're seeing additional team members come in to handle video editing, exhibit preparation, and planning, to name a few. Most of the time, the trial tech or hot seat still does the entire case from soup to nuts, and you as budding trial techs should be aiming to be able to do just that. At that one particularly large case involving an oil spill, now this is just talking about the firm I worked for at the time, so keep in mind that there were multiple firms involved with their own trial tech teams. We had 3 primary trial techs that were consulting with the legal team and presenting in court, but also a large team of video editors, exhibit preparers, and an independent vendor team just for trial setup and managing the video screens in court that assisted all firms. Law firms that get it will have a tactical advantage because they will have the most options and confidence when it comes to evidence presentation. And those firms that don't will be doomed to failure and highly visible mistakes in open court. A quick side note. This is an area that is very confusing to me. Why do legal teams shortchange themselves at the most visible and stressful part of the case? We see firms of all sizes come to court with bad trial presentation planning all the time. They can't keep up. They make frequent mistakes, and the mistakes are high profile. They make bad decisions about planning or equipment or personnel, and it's just so short-sighted. A small investment in people and software to have things run efficiently and professionally, and the firms that don't get it are only hurting themselves and their reputations. We have many goals in this class to get you up and running being a great trial technician. The first few weeks are about learning about the foundational elements of being a trial tech, like exhibit considerations, courtroom planning, and using PowerPoint for opening and closing. We'll then get into the basics of trial director and other important topics throughout the class. For this week, we'll be talking a bit about the basic skills necessary, the EDRM or Electronic Data Reference Model, the power of negative thinking, the different points of view, and on your own time, I'd like you to install the software packages provided. Last, we'll emphasize the importance of redundancy and quality control every week to ensure this message gets across. Now, I'll assure you, everything will not be a PowerPoint slide for the duration of the class, but the first few weeks will be while we learn the basics that are often missed by new trial techs that are foundational in knowing how to competently present a trial. I'll give you an example. I'm going to tell you and show you how to tape down cables and what type of tape to use. It's called gaffer's tape. You'll think it's silly until you see some ding-dong rip up a large swath of carpet in the courtroom when they use the wrong kind of tape. It sounds like this. Imagine this sound with the judge and clerk running out wide-eyed to see the calamity that just occurred. And tell me then that hearing what kind of tape to use is silly. The focus of our class will be on building skills and knowledge regarding the use of trial presentation technology, but we'll also put significant time into the companion skills necessary that make up a good trial tech. We'll provide a rubric by which students can assess if a particular opportunity is right for them. Sometimes the best choice is using an experienced vendor rather than to go out like a firework, public and spectacular. We also want to give case managers and administrators the knowledge necessary to understand the trial technology needs of a case so that good choices can be made as to staffing, budgeting, and presentation options. We want them to make good choices about budgeting and equipment, workflows, staffing, time estimates, and we don't want them to overburden the tech with unrelated tasks. Now take a look at this skills assessment. Don't worry if you don't have all the beginning skills yet. We'll get there. It would be helpful if you looked at the IT skills section, which is blown up on the next slide, as we'll be going through this in the coming weeks. Note that the skills mainly revolve around connecting your equipment to other equipment, but one of the most important skills is understanding how the courtroom environment you are in can affect the way in which your presentation looks. Connecting your laptop to a projector is pretty easy, but if you don't know how to connect and configure your laptop to different shaped monitors, your presentation will look like an egg, such as in the example in the lower left-hand corner. Likewise, if you use too high of a resolution in the creation of your presentation, but the courtroom can only use a low resolution, which, by the way, is very common, you will have problems, just like you see here in the lower left corner. Imagine your exhibits or PowerPoint being distorted like these examples in the lower portion of the screen. It happens all the time. Potentially hundreds of hours and thousands of billable dollars in the preparation of a presentation, and it's ruined in seconds because someone simply didn't determine if the screens were a square or a rectangle, or determine the capabilities of the courtroom presentation system. This is one reason why we'll be talking quite a bit about how to evaluate the courtroom so that we can make good decisions about how to set it up and plan your presentation so that it looks right and works right the first time, which, by the way, is the only time you can present it. So it's not really about just pushing the buttons and putting an exhibit on screen. Most courtrooms are not high-tech, and the ones that are usually pretty horrible, and we end up supplementing in some way. They typically have a mismatch of the monitor types that I showed on the previous slide, which causes the egg issue. A trial tech needs to know how to take the courtroom apart and put it back together, troubleshoot problems both technical and personal, be a bit of a diplomat as well. Moreover, they need to be able to build an effective base of technology by making good tech decisions at the beginning and throughout the case to help your team win. This all comes before you ever present an exhibit on screen. I look at the high-tech courtroom pictured here on the right and think it's great, but I have attorneys that would hate it because monitors are everywhere and it would be difficult to keep the jury in focus. Looking at the other courtroom on the left, I wonder how I would configure it with its size and space limitations. We'll be talking about how to create a courtroom plan in Week 3, Courtroom Setup. So I talked in the last slide about creating an effective base to base all of your trial presentation databases on as you move forward. And that means making good decisions throughout the litigation life cycle of your case. The litigation life cycle is also called the EDRM, or Electronic Discovery Reference Model. If you aren't familiar, I'd recommend going over to edrm.net and gaining basic familiarity with the process, as it's an industry standard way of referring to the various points in the process. In addition to being familiar with the EDRM, I provided links to 3 different web sources for great information on trial presentation. First, the Trial Presentation and Lit Support podcast put on by Rob Help, which goes over technical issues and interviews software providers and courtroom techs about their experiences and advice. I'd especially recommend 2 podcasts here, First Time in the Hot Seat and PDF versus TIFF. But the interviews with techs are also very good. I'd also recommend the Court Technology and Trial Presentation blog by Ted Brooks, which offers a wealth of technical information like projector standards and other valuable info on trial technology. I was having a problem where all my highlights looked dark mustard brown instead of bright, crisp yellow. Ted had the answer with his discussion on DLP projectors. Last, the Trial Technology LinkedIn site is a great place to post your questions. All of these are must-have sources of information. Are they nerdy? Absolutely. But they are also a great source to build your case for the right kind of equipment when talking with those that make purchasing decisions. Now, the power of negative thinking. You've all heard of the power of positive thinking. I'm going to introduce you to the opposite, the power of negative thinking. As a trial tech, you need to think of all the things that can and will go wrong and have a plan to counter. That fear of what can go wrong is a survival instinct for the trial, and a healthy fear that helps you anticipate what to do in case of a problem. For example, what will you do if your equipment is lost, stolen, or broken? Your tech gets sick? How to handle equipment failures and just generalized problems that make things go badly. You need to think critically if you have the tools, which include the knowledge, staffing, budget, equipment, and legal team support to succeed for any given case. If not, you really need to reconsider and put on the brakes until you have those elements. Nobody comes to you in the middle of a trial to say, hey, you didn't have enough money for the trial laptop. So sorry, your presentation looked wrong. But if you think about this in advance negatively, you might understand through testing at QC that things aren't working right or won't work right. Another thing to keep in mind is the point of view of the judge, clerk, and legal team you are working for. Always keep this at the forefront of the things you do in trial. The judge and clerk want efficiency and for the courtroom to be in one piece after you leave. As a matter of fact, as a trial tech, you should make sure it's in better shape than when you first got there. While your attorney is probably thinking they want to be persuasive and how to put on a good case. What makes a good trial tech? So a good trial tech is technical and creative. They're a consultant. They're organized, dependable, and confident. It's a very diverse skill set and a very hard one to find. Here are some suggested primary responsibilities for tasks at trial. Many need to come from the partner in charge of the case and others from the administrator and other members of the team. You want to be careful to not overburden the tech with tasks unrelated to their duties and that they are not overburdened with your particular case's needs. Always evaluate your staffing to ensure you don't need more tech people. It doesn't matter if your case is a big or small case in your mind. If you request that they make 500 video clips and prepare hundreds of exhibits in a short span of time, you'll either need more people or suffer on QC. Sometimes there simply is not enough time in the day if you are understaffed. Last, that is not to say that the trial tech shouldn't be a team player and do a pizza run or help out with tasks, but smart decisions need to be made in order to keep the hot seat fresh, alert, and with enough time to take care of their responsibilities. You do not want a sleepyhead trial tech in the courtroom. Trial by fire is often how techs describe their first trial experience. It shouldn't be that way, and so many are turned off after their initial experience that they never come back. It's a horrible experience being thrown into a situation where you might not have the right equipment or support to get the job done, or what often happens is the legal team underestimates the technical difficulty of the case. And so they either get the tech involved too late or don't provide them the support they need. People react to court in very different ways. Some relish the pressure and stress, while others not so much. I've seen people turn away at the courtroom doors out of fear and wash out due to substance abuse issues or stress. The stress is real. The entire case is often resting on the shoulders of the tech to make sure that it runs smoothly. Administrators and managers need to recognize how difficult the tech job is and keep an eye out to ensure they aren't getting overwhelmed. The tech can be a single point of failure that can really ruin everyone's day. So take care of your tech administrators and managers and have your own backup plans in case something goes wrong. Think negatively. When legal teams don't provide their tech with the appropriate tools or time to prepare, they are shortchanging themselves. At the end of the day, visible errors reflect upon the lawyer presenting the case first and the tech second. So keep that in mind when decisions are being made about the case. Risk management. It is just as important to ensure that you have both a good risk management plan and a professional presentation. How many hours will go into creating the exhibits, video edits, and data loads versus creating a safety net and backup? Think about it. Avoiding failure, embarrassment, mistakes, and minimizing their effects when something bad does happen is very important. You must ensure that the show goes on and always keep uptime as an important goal of your trial presentation plan. Many never recover from problems in court. 2 to 5 minutes or more for a restart and troubleshooting is a long time in court minutes, especially if it happens repeatedly. So we're going to be talking a lot about redundancy and quality control. Redundancy and quality control are about managing the risk of something going wrong. Redundancy in the trial tech context is duplicative and backup equipment and data ready to go to keep working when computers crash. And quality control is checking and rechecking to ensure everything is present and working. A central theme of this class will be being able to recover from errors and practicing failure and what to do when it happens. And that's a when question, or a when statement, not an if statement. Failures happen, and you need to be able to recover, and you need to have practiced this with your legal team because you don't want them in shock when it happens. Here are my 2 favorite quotes about preparation and trials in general, but seem to be particularly on point on trial technology. So the first one is by Abraham Lincoln. If I had 8 hours to chop down a tree, I'd spend 6 sharpening my axe. So that goes directly to preparation. Teams simply underestimate the amount of time that preparation, good preparation, takes. And this is a good quote to throw out. when people are saying or maybe calling to question how much time you'll need to prepare for a case. And the second quote is just an enjoyable quote by, and never truer, never has anything been more true said about going to trial, by David Boies, who's a very famous litigator. Do you want to win or do you want to sleep? There's not very many sleep-filled nights when you're at trial. Horror stories. I can't teach a class on trial presentation and not tell you the horror stories that occur, because maybe that's the only way to scare some of you into doing it the right way. I've seen people come to court not knowing how to connect their laptop to a VGA cable. So opposing counsel doesn't look so tough when they are begging the trial tech to help connect their computer to the presentation system of the courtroom. I've seen a number of version control and communication issues that led to documents that should be redacted being presented on screen unredacted. Very awkward. It's among the most fatal of errors trial techs can do. I've seen trial techs get kicked out of the courtroom and asked to shut down because they simply had too many crashes, and that usually results in the judge, asking the trial tech that did it right to cover if they wouldn't mind. And I've seen what happens when computer equipment is lost or stolen and there's no backup available immediately for use. So this takes us to the last slide, which is the assignment for this week, which is to install all software. Be sure to download the sample data set. This is going to be the source of a lot of our projects in the class. You should install Trial Director last so that its DLL files take precedence over anything else that's being installed. The software is pretty good, but it can definitely conflict with other types of software, like encryption software and some video players. So for our learning purposes, we should be okay, but of course you would want to test and QC your trial equipment that you were going to take into open court. So very important thing to do. I would also like you to introduce yourself, let me know your goals, introduce yourself to your fellow classmates. And last, this is my contact info. Here's the email addresses I can be reached at. Shannon.bales@mto.com and shannonlexbales@gmail.com. This is my mobile phone number, 714-478-7426. Please shoot me an email or give me a call if you're having problems with the class, or are getting behind or have questions. I want you all to get through the class, and I want you to enjoy it. So let me know what I can do to help you out. I'll make time to be available, and we'll get through this. Well, that's it for this week. I wanted to tell you how excited I am to be teaching trial presentation technology. This is a real thrill for me, and if there's anything I can do to help you get through the class, please just let me know. Thank you.